Hello, good evening, everyone. Welcome to day 10 of 30 of real estate content. My name is John Olisa, and I'm the CEO of Red Diamond Properties Limited. Yesterday, I started talking about the 10 types of land titles in Nigeria, or generally part one of the valid land titles in Nigeria. And today, I'm going to be continuing on them. Yesterday, I told you about right of occupancy, which is also called customary right of occupancy. I also talked about certificate of occupancy, which is also called statutory right of occupancy. I shared also about a deed of assignment. I shared also about a deed of gift. And the last but not the least, which I shared, was on a land excision gazette. Land excision gazette. For those of you who were not around yesterday, I want to recommend that you go to my YouTube channel so you can watch it. And I said these land documents are generally documents that show the true ownership of a land. They are also documents that can be used to transfer documents to another person from the current owner to a new owner. So the sixth one I want to talk about today is a court judgment. And generally, when two parties have a dispute and they go to court over a land dispute, many times the judgment of the court, especially a certified true copy, can be a valid land title. So there's dispute over this land. Who owns this land? Person A claims to own the land, person B claims to own the land, and in the matter, person A wins. That judgment becomes a valid land title. However, a point of caution for those who might want to rely on a court judgment. You need to know that many times in a land matter, the court that will give a judgment is the High Court, the State High Court in this instance. But even though it's a valid and subsiding judgment, the party that loses may appeal to the Court of Appeal and even finally appeal to the Supreme Court. And these higher courts can overrule the decision of the High Court. So you need to be sure that before you want to rely on a court judgment as a valid title, you need to be sure that there's no appeal on the matter. Because if you rely on it and the matter goes on appeal, and the party who lost at the lower court, whether the High Court, goes to Court of Appeal and now wins, it overturns the decision of the lower court. So that's one thing you need to be aware of. You also need to be aware of the difference between a court judgment and a court ruling. A court judgment is a final decision of a court at the conclusion of a matter, while a court ruling is a preliminary decision of the court during the course of the matter, on a matter that is brought up, on an issue that is brought up. And it's very important that you know this difference because some people will brandish a court ruling as a court judgment, and if you're unaware of the legal difference, you may fall to it. So know there's a difference between a court ruling and a court judgment. So that the court judgment is also a valid land title. The next one I want to talk about is a deed of mortgage. Now, generally, a mortgage is a transaction in which someone buys a house, right? And someone buys a house and is spreading payment over a long period of time over that transaction, over the house. And the document that is transferred is called, the document that is used is called a deed of mortgage. Yes, it's called a deed of mortgage, right? And the person, or much more importantly, when the person wants to get a house, right, they use their house, they use the house as a collateral, and it becomes like a mortgage. So the person who is borrowing money is called the mortgagor, and the person who is giving money is called the mortgagee. And the document that encapsulates that relationship is a deed of mortgage. Ideally, when the person who is borrowing money pays back the money, what will happen? The ownership of the house, the full right of the house, will be returned to the mortgagor. But if the mortgagor does not pay the full money, the mortgagee, after the mortgagor has exhausted all the legal rights of redemption, has exhausted it, and has exhausted it totally, the mortgagee can now sell the house to another person. And the document that will be used to show that transaction is called a deed of mortgage. So a deed of mortgage is also a valid land title. A deed of mortgage is also a valid land title. And I'll go to the eighth one, which is a grant of probate. Ideally, before a person dies, a person can make a will. A will is a document showing how a person wants their assets to be distributed upon their demise, upon their death, and it's usually made in the lifetime of the person. The person ideally would appoint somebody called an executor to execute the wishes stated in the will, and the person will usually list out people who are called beneficiaries, who will be the ones that will benefit from the assets stated in the will. So when such person who makes the will now dies, the person is called a testator. In law, we say the person dies testate. The people who will execute the content of the will, called the executors, will go to the court. And if there is no dispute over it, they will ask the court for a document called grant of probate. And with that grant of probate, they can now use it to execute the desires of the testator, which can also include transferring land to beneficiaries or other people. So such grant of probate is also a very valid land title. Then I go to the ninth one. There are instances in which a person dies without making a will. Such instances, it is said that the person dies intestate. The person did not make a will. The person maybe died in an accident or just died without making a will. The person is said to die intestate. So what happens in such instance? There are people who can approach the court to give them a document to, based upon which they will now administer the properties of the dead person. And the document that will be given to them is called a letter of administration. And based on that letter of administration, they can now administer the property of the person who died intestate. Now the question you need to know is that there are people under the hierarchy of law. There are people to whom letter of intestate can be granted to. There are people, and I'm going to list some of them in order of the hierarchy. Those who could be appointed as administrator. One is first the spouse of the deceased, next children of the deceased, next parents of the deceased, next siblings of the deceased, next half siblings of the deceased, then grandparents of the deceased, uncles and aunties of the deceased, creditors of the deceased. Then the last but not the least is the administrator general. So such people in order of the hierarchy can be granted letters of administration by the law to now utilize the property of the deceased person or share the property of the deceased in line with the laws of the state. So that is what a letter of administration is. And the last land title I want to talk about is called assent. Now I've talked about the fact that if a person dies intestate or if a person dies testate, the document that will be used is called a grant of probate. If the person dies intestate, that is without a will, is called a letter of administration. Now, when such properties are granted over to people or assets granted over to people, but in this instance, land granted over to people called beneficiaries, the document that is given to them showing a proof of ownership in this instance of maybe land is called assent. Assent. And this is my definition of assent. I said it's a document that transfers titles in land from the executor of a land or an administrator to the beneficiaries of such will, or the property is transferred to people who died without making a will. And such assent is usually given alongside what we call the grant of probate or the letter of administration. But one thing you need to know is that assent cannot be given to everybody as a land title. Assent is specifically given to people who are beneficiaries of either the will or their... Sorry, I had a call that came in. Sorry, a call came in, so it disrupted the call, but we are back. So back to what I was saying about an assent. An assent can only be given to beneficiaries in a will or those in the letter of administration. An assent cannot be used as a document to transfer ownership to non-beneficiaries. So let that knowledge guide you. And there was a case that was stated to be. It's called the Risterops case. So that's what you need to know in summary about 10 valid land titles, from right of occupancy called R of O, customary right of occupancy, to C of O called statutory right of occupancy, to deed of assignment, to land acquisition gazette, to deed of gift, to a court judgment, to deed of mortgage, to grant of probate, to letter of administration and assent. It's always important that you engage lawyers to help you in any land transaction, because they know they know the pitfalls that you should avoid, and it will really help you make it much more easier for you. It will help you do due diligence and the like. So it's always important that you have knowledge about the law, knowledge about every business you want to go into. I've said this repeatedly over the last 10 days, that the most important rule of investment is this: before you so before you invest in any business, invest first in acquiring knowledge about the business. Before you invest in any business, invest in acquiring knowledge about the business. I'm the CEO of Red Diamond Properties Limited. We're a property development company, and we have our first estate in Kuchiyako, Koje, Abuja. With 200 square meters, you can get a plot of land where you can build a 3-bedroom semi-detached duplex, and it goes for 1.5 M. With 300 square meters going for 2.3 M, you can build a 4-bedroom semi-detached duplex, while with 400 square meters going for 3 M, you can build a 5-bedroom fully detached duplex. And also on 1,000 square meters going for 3 M, you can build 6 units of 1, 2, 3 bedroom flats, 2 units each. So please contact me on +234 813 799 0792, +234 813 799 0792, or you can send an email to reddiamondproperties10@gmail.com. Thank you so very much for joining me in today's live. I sincerely appreciate you. I continue tomorrow, where by God's grace I will go back to continuing my discussion on different ways you can make money in real estate in Nigeria. So I just took a break for about 2 days to talk about land titles, and I'll still talk on other things: how to avoid real estate scams in Nigeria, how to even detect these scams, how to report if you have been scammed, tax on real estate, on real estate, the Abuja real estate market, and so much more. We have 20 days more to go. And for those of you who can't join live, you can go to my YouTube channel, John Olisa, to catch up with the past broadcasts of Miss and what we're going to be doing subsequently. Thank you so very much for joining me. I appreciate you. Have a good evening. Bye.